Please come to order. All please rise. The judges of the New York State Court of Appeals, and His Excellency, the Governor of the State of New York. The Law Day ceremony will now begin. All please be seated.
Good afternoon. I'm pleased to welcome all of you here and thank you for joining us in the celebration of Law Day. Before we proceed, I'd like to acknowledge the presence of the Governor of our state, the Honorable Mario M. Cuomo. Attorney General Robert Abrams. Matthew Crossan, the Chief Administrator of the Courts. And New York State Bar Association President John Bracken. I'd also like to recognize just a few, a very few, among this highly distinguished audience today. I know what a risky business this is, especially for a first-timer. Mayor Thomas M. Whalen. Presiding Justice Leonard A. Weiss of the Appellate Division, 3rd Department. His predecessor, seated right next to him, Justice A. Franklin Mahoney. Judge Joseph Traficante, Jr., Deputy Chief Administrative Judge for the courts outside of New York City. And Judge Milton Williams for the courts inside New York City. And Jonathan Lippman, the Deputy Chief Administrator. Donald Corbett, the Presiding Judge of the Court of Claims. And so many other members of the Judiciary. I'm also especially delighted today to welcome our friends from the legislature whose presence here today is so particularly reassuring to us in the judicial branch. I see Saul Weprin, the Assembly Speaker. And Clarence Rapelier, the Assembly Minority Leader. Christopher Mega, the Chairman of the Senate Judiciary Committee. And Oliver Coppell, the Chairman of the Assembly Judiciary Committee. And so many others in this audience. I'm going to stop here just with a general welcome to all of you. Anticipating today's celebration, I've done a little research into the event, and I've learned that Law Day was started in 1958 as an American response to the Soviet Union's May Day celebration. While communist nations celebrated May Day with massive military displays, in the United States, we have dedicated a day to reflection on the principles and institutions that preserve our freedom and our democracy. Today, with much of the communist world taking its first tentative steps toward democracy, we have more reason than ever to be thankful that we are a nation governed by the rule of law and not by military might, and to renew our commitment to maintaining the constant vigilance that is the price of freedom. Few have been more vigilant in the pursuit of justice than the President of the New York State Bar Association, John Bracken, upon whom I now call.
Governor Cuomo, Colonel Abrams, Matt Crossan, colleagues and honored guests. I have been in this court a number of times, and I must tell you that it was with great trepidation that I turned my back on this court. It is not something I would ordinarily do. I have some solace, I suppose, that I have two lights in front of me. One is red and one is white, and I know about those. But it is indeed a pleasure to be here and to have this opportunity to address you. In recent years, much has been expressed about the importance of ensuring that the executive, legislative, and judicial branches of our government continue to be co-equal, not only in name, but in practice. Much has been said about the value of preserving the principle of separation of powers of the three branches. President Franklin Roosevelt once described this form of government as a three-horse team with the people in the driver's seat. These tenets forged by the founders of our government have withstood the test of time and remain as vital today as they have always been. The well-being of our system of justice, however, is now at a crossroads. If today's demands on the legal process are to be answered, there's an equally crucial concept that must be utilized to the fullest. This is the need for coordination and cooperation among governmental entities, as well as the bench, bar, and community in addressing the issues affecting the justice system. Never before has the need to work together been more critical as caseloads climb, as the myriad of legal matters become more complex, and as the availability of financial and other resources dwindles in these tight economic times. Never before, however, has there been more opportunity to take concerted action. Inaction sends to current and prospective members of the bench and court personnel a most discouraging and demoralizing message that the justice system is not considered a priority. Inaction also reinforces this perception among the public. Now is the time to make change in a positive direction. We have seen a number of positive steps this year, such as approval of the first compensation increases for the state's judges since 1987, improved funding levels for court system operations in the new state budget, and avoidance of further hikes in court fees, which would have had the practical effect of placing the justice system out of the reach for more citizens and small businesses. The New York State Bar Association has been a staunch and persistent advocate of raises for the judiciary and adequate financial support for the courts. We have been an equally strong opponent of additional fee increases. These recent measures by the executive and legislative branches are indeed heartening and are illustrative of our effort to work in tandem for the public interest. It also exemplifies that this year's Law Day vision of everyone striving for justice can, in fact, be practiced with positive results. We will continue to work diligently to perpetuate this spirit. The judges whose portraits grace this room have expressed concern about many of these same matters in years past. It has been said that the difficulty in achieving movement on court-related issues is that the judicial branch's constituency is limited to the legal profession. I contend that the problems and needs of the courts are the concerns of society in general. Additional efforts of outreach and education are essential to effectively communicate the importance of these matters to the public and to seek prompt resolution of these concerns. A case in point is the pressing need to ensure that steps are devised to remedy the overcrowded, inadequate, and in some instances crumbling conditions of court facilities in various areas of our state. We have all seen firsthand, and in pictorial essays, I might add, vivid examples of this deterioration. The dearth of the most basic modern equipment and space stretched far beyond capacity. Mentioning of mice and men in court will not conjure up images from a John Steinbeck novel, but instead will bring recollections of the time a mouse fell through a hole in a courthouse into counsel's lap. The need to provide adequate facilities and funding for our courts was described 22 years ago by Chief Judge Stanley Poole, who observed that, and I quote, "The judicial system, however, cannot live by light alone, or even by the heat of lusty exchange of diverse and varying views. Certainly it needs responsible rhetoric, but it needs resources even more." Our association has persevered tirelessly for this cause. Progress has come in increments over the years, highlighted by the enactment of the Court Facilities Act 6 years ago. Despite the progress made and the indisputable evidence that these are basic needs, not frills, we recognize that bringing these construction plans to fruition remains a challenge. In light of fiscal difficulties, the program is experiencing delays in some areas, and some municipalities have requested deferral of work. A provision of the Court Facilities Act permits the withholding of state aid when a community fails to meet its obligations. Last month, our House of Delegates went on record favoring use of this sanction when other measures do not achieve results and when default of a locality has been finally determined. Yes, this is strong medicine, but we consider this a priority issue. The efficiency of and respect for our courts is undermined when these facilities are allowed to deteriorate. We commend Chief Judge Kaye for taking the immediate step of visiting the court facilities across the state as part of her efforts to remedy these conditions. Progress will require the concerted effort of the entire bar in increasing the awareness of the public and the community leaders and the coordination and cooperation of local and state governments. Change in the process of selecting our trial-level judges is long overdue. The need becomes crystal clear when we consider the realities of the present system of election, the escalating costs of campaigning, the partisan political control, the trend to cross endorsements, and the lack of opportunity for real participation and choice by the people. As Chief Judge Charles Bartel told the legislature almost 20 years ago, we must face the fact that today the selection of judges by the elective process is, ironically, the least responsive to the public will. Instead, the people are given choices in name, but not in fact. The State Bar Association has not come to this position recently, nor have we placed it on the back burner. Each and every year since 1979, we have presented as part of our legislative program in the hope that the legislature will adopt a merit selection plan and allow the people of the state of New York to vote upon it. Once again, and most recently, the House of Delegates of the State Bar Association voted again in favor of merit selection. Since that time, I might add, and since 1979, additional studies, court decisions, including the United States Supreme Court ruling in Chisholm versus Romer and other developments, have underscored the need for change to provide for a more open selection system that accomplishes the following. 1, reduces the involvement of partisan politics in the process. 2, facilitates, encourages, and heightens awareness of opportunities for judicial service, fosters greater diversity reflective of the community, and brings the very best of our profession to the bench. We applaud Governor Cuomo for his continued support of the merit selection concept. Following the examination of these developments, the Association's Action Unit Number 4 in court reform, formulated a model plan calling for the establishment of nonpartisan commissions of lawyers and laypersons to recommend 3 candidates for each open slot for appointment by the appropriate executive. In April of this year, our House endorsed this plan in principle and further called for the use of retention elections at the conclusion of the terms of incumbent judges who wish to continue service based upon the recommendations of a public commission. Certainly, changes in resources in the selection process would be major milestones in improving our justice system, but more must be done in implementing measures to enhance its efficiency and effectiveness. The inequity of the tremendous caseload carried by the Appellate Division's Second Judicial Department is a pressing problem that cries out for resolution. It is now so many years that we have dealt with the problem in the Second Department that it is beyond my ability to describe to you what has occurred. The Second Department now has more than half the population of the state of New York, and in fact, we are still divided along 4 departments as was originally done in the 1860s. The inequity is obvious. Conditions are so severe that, for example, almost 2 years elapse before an appeal can be heard. 8 years ago, the Association called for the creation of a 5th Judicial Department to help balance the workload among the jurisdictions. Since then, we have proposed additional measures to aid in addressing the situation. The cooperative and immediate efforts of the 3 branches of government are desperately needed in pursuing a constitutional amendment to bring relief to the justice system in the Second Department. The State Bar Association has made a number of recommendations, including streamlining the exchange of information in civil matters, expediting discovery under the criminal procedure law, giving the court discretion in ordering jury sequestration and accepting Class A and B felonies, and providing input on the functioning of the individual assignment system. The court system should be cited for its ongoing efforts to propose legislation and implement management and technological improvements, including the development of the management review study performed by the National Center for Study of State Courts and the Judicial Research Institute. Certainly, this report should be viewed as a springboard for follow-up action and analysis in regard to various courts of this state. Our association members are a tremendous resource of experience and expertise through their work on a daily basis in the various courts across the state. We are continuing this study to provide our perspectives and will continue to be actively involved in working with for the best interests of the justice system. We would stress, however, the need to go beyond enhancing specific functions. As the management study advised, and I quote, "For the judicial branch to fully achieve its vital constitutional role, the other two branches of government must constructively participate. The public needs to take cognizance of the needs of the system and become a partner with the judiciary in its efforts to improve the system. Legitimate criticism from all quarters can spur needed change. However, conditions and coalitions must be formed." In a 1964 speech to the State Bar Association, Chief Judge Charles Desmond cited the improvements made in the substantive law to keep pace with changing times, but noted that, quote, "Our procedural and administrative machinery has not always been similarly overhauled and re-geared. The bar," he said, "must not only provide expertise, but assume responsibility in persevering on these matters." Judge Desmond shared an old saying, which is especially apt as we contemplate the road ahead for our justice system and the importance of our active involvement in shaping its future. Four things never come back: the sped arrow, the spoken word, the past life, and the lost opportunity. Let's pledge today to do all in our individual and collective powers in fostering cooperative efforts to forge a judicial process that is most effective and responsive to today's needs. Thank you very much.
Thank you, President Bracken. Our next speaker has, for several decades, served the state with great distinction, Attorney General Robert Abrams.
Thank you, Chief Judge Gay. Although Governor Cuomo reminded me several decades, makes me into a very old person. But politics is a hair-raising experience. Chief Judge Kay, Associate Judges of the Court of Appeals, Governor Cuomo, President Bracken, Chief Administrator Matt Crossan, and friends all. Today, we salute the importance of the law in our society. And I think we must remember how fortunate we are to live in a land that is ruled by law. In so much of the world, the rule of law is simply a phrase without meaning, a hollow promise to the people. Although its shortcomings are evident, our system still offers the most expansive and accessible system of justice found anywhere, a system that offers substance as well as procedural rights to all Americans. We cannot, however, rest on our laurels. The challenges that we lawyers face as a profession are serious and they're real. My focus today is on a very unpleasant reality. The legal profession is not held in high esteem by the American people. Last year, for example, the American Bar Association hired a communication specialist at $170,000 to improve the image of lawyers in the United States. While I do not expect the sport of lawyer bashing to disappear, I propose that those of us who are members of the bar use the opportunity of Law Day to reflect on initiatives that we can and should take to enhance public confidence in our profession. This year in New York State, we've been reminded again of the public's dislike of the legal profession. In hearings conducted over the past several months by the Committee to Examine Lawyer Conduct in Matrimonial Actions, appointed by the Chief Judge, we have heard many compelling voices criticize the conduct of lawyers in matrimonial cases. The committee has heard gripping testimony of serious complaints against lawyers, mostly by women in divorce cases. Shockingly, many of these women reported that when they filed formal complaints against attorneys, the complaints were ignored or simply dismissed by disciplinary committees. Dissatisfaction and disgust with our system of lawyer discipline and cynicism about whether we even have the ability to police our professional conduct were repeated refrains in the testimony that was offered. The charge that serious complaints about lawyers are summarily dismissed by other lawyers is not confined to the matrimonial bar, although they have been perhaps unfairly singled out as the targets of much of the public criticism. The perception persists that lawyers as a group are arrogant, insular, and unresponsive. I believe that we can no longer ignore the public's dissatisfaction with the status quo. Our failure to open the attorney disciplinary process to greater public scrutiny has detracted from the public's confidence in our legal system. Although significant strides have been made to make the legal profession more diverse, the image remains that we have hidden behind the veil of secrecy to protect our own from criticism. This perception must be changed. I believe we should take concrete steps to restore greater accountability and improve confidence in our profession. In addition, we need to send out an unambiguous message that we hold ourselves to the highest professional standards and ethical considerations. So today I place before you 3 recommendations to improve the disciplinary process. First, except for frivolous complaints and those that do not survive initial scrutiny, disciplinary proceedings and files should be more open to the public. Second, the person filing the complaint should be provided with greater information about the decision made by the disciplinary committee or the courts, particularly when a complaint is dismissed at a very early stage. And thirdly, time limitations should be imposed on the handling of complaints, ensuring speedier resolution of those complaints. Currently, the judiciary law requires, unless the court rules otherwise, that attorney disciplinary matters remain confidential until the appellate division finds that discipline is warranted. The rules of the 4 departments differ markedly in the details of the process. But in all 4 departments, there is a point at which a complaint is either dismissed or proceeds to the formal presentation of charges and a hearing. At that juncture, I believe the public's need to know outweighs a lawyer's legitimate desire to protect his or her reputation. From that point on, I suggest, matters should no longer be deemed confidential unless the court determines otherwise for good cause shown. Some attorneys have a misplaced fear that greater openness at this or any stage of the proceeding will unfairly ruin reputations based on frivolous or worthless complaints. But what I propose here protects the innocent lawyer from disclosure of such complaints. Now, because the public is never informed of even serious investigations of wrongdoing, the most ethical attorney is never free from public doubt or question. Under this proposal, the frivolous complaint would be dismissed in confidence as it is now. Meritorious complaints, however, would be subject to a more open, scrutinized administrative process. Concern that public exposure will chill the filing of complaints has proven unfounded. In fact, 28 other states in this union have adopted similar or even more extensive disclosure provisions without any noticeable harm to complainants or to attorneys. Further, both the American Bar Association and the Committee on Professional Discipline of the Bar Association of the City of New York have endorsed proposals similar to these. Both recommend that proceedings should no longer remain confidential after a probable cause finding is made. There's another way in which we can give the public greater confidence in our system, and that is to explain it better. Complainants will inevitably become cynical if their charges are dismissed at the earliest stage without any explanation whatsoever. We've got to find a way to explain the very system we use, the rules of professional conduct, the judiciary law, the case law, in a way that people can understand. In one case, a woman complained about her attorney, and when the lawyer responded, she filed further papers, carefully citing provisions of the disciplinary code. She later received a form letter dismissing her complaint without any explanation whatever. Clearly, a letter dismissing a complaint should provide at least a brief explanation of the reasons for the dismissal in plain, understandable language. The complainants that we have talked to would surely have benefited from that and would have believed that the system was much more meaningful than had been provided and had left that person. Let me suggest another change that we've got to adopt in order to professionalize the process itself, and that is to impose stricter time requirements on the handling of complaints. I know of one complaint where the attorney supposedly was allowed 20 days to respond, but in fact 7 months went by before there was an answer. When the complainant objected to the time delay, he was informed that nothing could be done about it. In another case, the grievance committee waited 1.5 years after the complaint was filed and then closed it without any comment or explanation to the complainant. My own experience is not much better. My office filed a complaint against a criminal defense attorney after a very highly publicized investigation, and it is still not resolved 4.5 years later. While making these suggestions, I don't criticize the committees or their hardworking staffs. I know that without adequate resources and faced with increasing numbers of serious complaints, they've done the best that they could to impose strict discipline where appropriate. In many cases, my office has worked hand in hand with disciplinary committees, for example, in bringing criminal tax charges against attorneys who have failed to pay state income taxes. I urge that they be provided adequate funding to perform their job in the most professional manner possible. But I feel obligated as Attorney General, as an advocate for those less knowledgeable about the law and its inner workings, to speak on behalf of the non-lawyer. While it is essential to have a system that protects the hard-earned and well-deserved reputations of the vast majority of attorneys, the public is entitled to confidence that the attorney discipline process is genuinely and actively protecting its interests. I believe that the proposals I outlined today will make our profession more accountable to those it serves and thus restore their confidence in our ability to serve them. The times when attorneys could hide behind their status and reputation is long gone, and we in New York must change with the times. Thank you very much.
Thank you, General Abrams. It's a particular pleasure for me now to call upon our next speaker, the Governor of the State of New York, Mario Cuomo.
Thank you, Chief Judge Kaye, members of the bench, John Bracken, Attorney General, Bob Abrams, excuse me, Matthew Carson. I'm delighted to be here again this year. I couldn't help but think, as the Chief Judge was describing the beginning of Law Day, what a miracle it is that this court system here in the United States of America is able to do so much with words alone, without an army to enforce its edicts or any form of coercive power. The miracle of the country's existence has been that for more than 200 years, by words alone, rights are created, property protected, opportunities inspired. It's also true, however, that the good things that this country needs to get done require more than words, and that becomes the function of the other two branches, the executive and the legislative. John Bracken more than anticipated what I intended to say to you today about the agenda of needs that are required to be met by more than words by the executive and the legislature. He's mentioned most of what I wanted to mention. But let me elaborate some of the points he made, and I thought he made them very well. When I nominated Judge Kaye for Chief Judge of the Court of Appeals, and then the Senate confirmed her in record time and enthusiastically, we gave the judiciary of this state a bright new leader, someone whose skills as a lawyer, legal scholar, and judge were incontestable. And the effect, it seems to me, on the court's morale was immediately evident. Now with this impetus, we should join in an effort to achieve a new reform of the court system that brings it new strength. That would have to begin by streamlining the current configuration of the court system. New York's court system today is too fragmented. It creates confusion, inefficiency, unnecessary expense. We've known that for a long time. We've known for a long time that we need to merge the courts into a single, unified trial court of general jurisdiction. I proposed a constitutional amendment to effect this badly needed merger, but I have proposed constitutional amendments before. I urge you, all of you, the judges, to the extent that you are allowed, the private citizens, the attorneys, to join in calling upon the legislature one final time, perhaps, to take a real look at the possibility of this constitutional amendment. And if they decide not to do it, then at least to pay us the courtesy of informing us that they don't intend to do it. It's been a long time. We asked for this kind of merger before the Court of Appeals went to appointment. We asked for it after it. I have asked for it explicitly, and I suggest that what we do now on this point and some others that I will mention about our legal system generally is to ask the legislature simply to say, yes, we will consider a constitutional amendment, or no, we won't. And if they say no, then turn your attention to another possibility, which I have talked about for some years, but which I think finally is going to attract the attention of the population of this state, a constitutional convention. If the established forces in the legislature, and the executive for that matter, that have made of incumbency a notable habit, I will have been here for 12 years. That's a long time to be governor. But that's nothing compared to the legislature. The Senate has been in control of the Republicans for about 53 years, with 1 year taken out. And the Assembly in the hands of the Democrats for about 35 years, or 36 years. Under all of these circumstances, isn't it appropriate to say at this point that it seems that perhaps your habits will not change suddenly? And maybe we ought to go back to the people, as the Founding Fathers themselves suggested, to review our 10 Commandments, the constitutional structure of the state, and to see whether or not it ought to be changed. You know, of course, that in the 60s, that was done in the early 60s, and the result of the convention was aborted because the people were confronted with a single complicated proposition, and there were many good things, I think, had they been done seriatim, that might have been passed individually, but of course they were bound together in a single package, and it meant that you had to deal with aid to church-related schools and a lot of other very confrontational and confusing issues. The whole thing went down. Before that, the only time that effective change was made was 1938. Well, isn't it time? Why should we each year go to the legislature and say, please consider merger? Everybody knows it's intelligent. Everybody knows it's right. Please consider going to the merit system. Now, that's a little more controversial. There are people of high intelligence and goodwill in the legislature who think it is better to have elected judges. I've had that debate for a long time. One of them was one of the great people in this court's history who has been referred to already, Chief Judge Charles Desmond, who was absolutely convinced that the merit system was not the best way to go and the elective system was. It had little to do with his commitment that he got to be a judge only because he was elected. He never would have been appointed for reasons that he used to describe himself with great eloquence and much fun. So I believe that we ought to consider merging the courts and doing it right. But if the legislature chooses not to, tell us so that we can go to the people and say, they have decided not to change this and a number of other things. Therefore, you have only one alternative. You must change it. And the manner and device for doing it is provided in the Constitution itself. Every 20 years, you'll get a chance. The next time is 1997. If you want to do it before then, ask the legislature, as I have now for 3 years, to simply give the people the opportunity to make some of their own decisions at a constitutional convention. It's a fascinating notion. And let's admit, to those of us who have been around for a while, what's happened. A lot of us who have been around for a while don't want changes. We're scared to death of changes. And with good reason. We've done very well. If you're governor for 12 years, who wants changes? Why should you change the system that elected you? Why should a legislature that's been in power for so long? Why should you tamper with the way you got elected? Why should you change campaign financing? Why should you consider term limitations? Why should you consider initiative in referendum when it's going so well from your point of view? My point is that it is not going so well from the people's point of view, not in the country and not in the state, and we all know it. Let me limit myself to the legal system, not just the courts and the judiciary, but the legal system. We need to reduce court congestion. I made an argument for a fifth department when I was 12 years old, it seems to me. They made one at the Constitutional Convention. I think it was in the Constitution that they put to the people. You need a new department. You can't do it with 4 departments. Why? Because it's wacky. You have one department that doesn't have enough and another department that has too many. It's silly. You have an avalanche of cases in the second department. For goodness sake, do something. Make another department. I defy you. Ask the lawyers to write a little essay on why it's never happened. Nobody really knows. It's just never happened. Why? Well, politically, it was never terribly attractive. It still isn't. But in the family courts and the Second Department of the Appellate Division, there's terrible congestion. With Chief Judge Kaye, we're examining ways to ease backlogs, including adding additional justices, shifting the 9th Judicial District from the 2nd Department to the 3rd Department. But frankly, I think we need more substantial change in that area. We must also provide our criminal trial court judges with the best possible tools for administering justice, including a statewide forensic DNA system to provide better evidence, a simplified discovery process to reduce time wasted in court, and greater discretion in sentencing. Still another helpful change. I think this one doesn't require a great deal, and it's a change by way of addition as distinguished from consolidation. The task force I set up last year has recommended we establish a new court, which would be patterned after the Chancery Court, now operating successfully in Delaware. Like the Delaware court, our new court would provide a prompt, efficient mechanism for handling complex corporate cases. We have a small claims court. Let's have a big claims court, you know, for those big, really ponderous cases where there's a lot of money involved and a lot of interest who would be willing to pay more money to get swift decisions in their big cases. You see the proliferation of alternatives to the judicial system. Some of our best friends, colleagues of yours, those of you who are judges from the bench, are now out there with other alternatives to the court system, arbitrating, saying, in effect, the court system is not your best device for arriving at justice. A very good friend of mine has now left one of the great Wall Street firms. So I received an announcement in the mail. He's going into the arbitration business. Give me those big Agent Orange cases. Give me those complex cases. I'll deal with them. Why do you need the judiciary? And a lot of people who understand these things say, good question. What does it tell us about our system if the alternatives are so attractive? We need a big claims court that would provide a prompt, efficient mechanism, and probably, if you did it right, and remember, you're not going to impose this on anybody. The people who will use that court will desperately want it, and they'll pay for it. You'll have enough to pay for the court, and if you do it exactly right, you might have enough for other courts that can't pay for themselves. It would be at least financially self-sustaining, but probably a good deal more than that. This proposal will require legislative action, and work still needs to be done to iron out details, but with the strong support of the judiciary, I believe it is achievable this session before the legislature leaves, which would be sometime around July, I would guess. The reliable delivery of justice takes more than logical organization, however. The places where our judges preside must be conducive to managing the affairs of justice. The courthouses are a mess in some places, a disgrace in some places. It's embarrassing to go to some of the courts, and it's bad for you as a society to allow people to see what should be the one preferred place in the hierarchy of governance, the one place surest to be pure and clean and above it all and above the politics and independent and objective and true and worthy, and to see it a mess. There's something inconsistent in the message you're trying to deliver to the people. And so we have to do more. Many communities finally have begun construction and renovation of their courts upstate. In New York City, the Dormitory Authority has developed an ambitious schedule for design, construction, and upgrading of 32 of the city's courts. That court facility approach will require the expenditure of $2.8 billion, but we are moving forward on that part of the program. We have to do more to fix the courtrooms. We have to fill the benches as well. There are now more than 20 vacancies in the trial courts. Judicial screening committees have been working overtime to draw up lists of well-qualified candidates. I've made several nominations recently to Albany, Rensselaer County Family Courts, Supreme Court, Manhattan, Nassau, and Suffolk, the Schenectady County Surrogates Court, and others. I'm urging the Senate to confirm the nominees as expeditiously as possible. I'm not suggesting they're taking too long. They don't. Frankly, the Senate has been very, very accommodating when it comes to passing on judges I send to. But I would ask them to deal with these as expeditiously as possible because the need is so great. This year's budget offered us some relief. It wasn't a great budget, but compared to what you got in recent years, it was a very good budget. It's a budget that provided the judiciary an increase of about $50 million, 6% over last year's appropriation. That was a pleasant change. Included in the judiciary budget, as you know, was the first salary increase since 1987 for the judges of the unified court system. In the next couple of years, most state judges will receive raises in the range of 20%. The raises are warranted, in my opinion, and I expect they will help further reinforce what has been a sagging morale among our judges. But let's stay with judicial raises. It's wrong for the judges to have to come to Saul Weprin and Ralph Marino and Mario Cuomo or whoever follows them on the political side of government. It's wrong for you to have to come to us and ask us for money. Why? Because it gets you unnecessarily entangled in the political process. We have to find a structure that handles this without that kind of intercourse. Just everything we have done with judges that's intelligent is designed to remove the judge from the political process. They dress differently. You're not elected the way we're elected in all cases. You're there for what amounts to a lifetime, if you wish. That's because we want you to be independent. There are laws about what we can do and can't do with your salaries. But to keep that independence, I think, and to give you more of it, there ought to be a mechanism that deals with salaries apart from the political process. We have made some suggestions. We'll continue to push them. We have to address an underlying suspicion in the hearts of too many people that the legal system we celebrate today, far beyond the system, is skewed against them because of their color or accent or the neighborhood they're from. Now, this is a very complicated issue. Diversity. How do you deal with it? We're very proud of the fact that this magnificent document that describes us, our 10 Commandments, the Constitution, created a system that probably was unique in world history, that not only allowed diversity, but nourished it, encouraged it. But it creates special challenges as well. Let me talk to you about a part of the system that goes beyond the court, the legal system. When I grew up in New York City, the public servants who protected us, taught us, and cared for us lived in the same great city with us. They were from us. The cop, Tony the cop on the street, had a tremendous influence, not just because families were different and values were different and the psychology was different and religion was more intact, not just because of that, but because he was one of us. He was like us. He came from us. He reflected us ethnically. He reflected us culturally. Public service was also one of the best routes residents had to travel from poverty to the middle class. Because they were raised from the city's population, they reflected to a great extent the diversity of the city they served. That's not true today, as it used to be. Our public servants today in places like the city of New York are certainly as committed as any in the nation. And I would do nothing to disrupt their lives at the moment, wherever they now live. But I believe, and have believed for a long time, you should return to the time when police, firefighters, teachers, and other public servants lived in the city that they served. A time when a policeman on the beat was protecting his or her neighbors. And most of the time was his because you didn't have hers in those days. And now we have made progress there. We need to make more progress, but we have to go back a step to another way of doing things. I would like to see a residency law. I've advocated it since 1977. It would act only prospectively, and what it would say, in effect, is if you're going to be a policeman here or a judge on a city court of some kind, live in the city. And if you're telling me that, well, you do not have the housing opportunities, etc., then let us work to give you the housing opportunities in the city. But be from us. This problem of diversity is a very difficult one for us. It affects us pervasively. And we need to do more to deal with it at the city level. We also need to do more with it in the courts. January of '92, a task force I formed on judicial diversity issued a report. Said, simply, there's clear evidence of an extreme lack of diversity in the state's judiciary. And there is. You know the situation. Send up 9 names, a lot of black names, one Latino name, and we wind up with a couple of judges who are none of those categories, neither of those categories. Well, what does that mean? Does that mean somebody's biased, somebody's skewed the screening process? No, I don't think so at all. What they did probably was go to the merits. And they said, we're going to do it on the merits. And the way it worked out is that the best were in neither of the categories that you were trying hard to reflect. But we need to find a way, obviously, where we can do both things at once. Number one, you need the very best people on the bench, and you cannot surrender that in the name of diversity. You need the highest kind of quality. We accept that. However, you can find all the quality you need for the bench among the women, among the Latinos, among the Asians, among the African Americans. And so it becomes a management problem for those other two branches of government who have to go beyond the words. It is the law that is allowed to deal in words alone. The rest of us must do things. We have to find a way to meet the challenge of diversity in the courts. One way to start, if it's an appointive system, then the appointer has a lot to do with that. But the screening commission operation, what we should do is make sure that all the screening committees have the kind of diversity that you're looking for on the bench. I have an executive order coming that will do more in that direction. Jurors. We have to do more with jurors. We shouldn't overlook these New Yorkers who are such an important part of the system. Worrisome reports indicate that New Yorkers from a variety of minority groups are shunning jury duty because they don't trust the system. We should reach out in a special way to African Americans, Hispanics, Asians, and others to make sure that they recognize the potential difference their participation can make. And we should examine the methods we use to identify jurors to ensure they're selected from a pool of the widest variety of people. Traditionally, members of the jury have been selected from lists of property owners, vehicle owners, and voters. If the lists we use to find potential jurors are unfair, we should look for other sources of names. Frankly, I think that in a place like New York City particularly, that kind of categorizing skews the kind of jurors that you come away with, and that has to be revisited. And finally, we cannot forget the victim. Justice for all means the fullest possible protection for the crime victim while preserving the rights of the accused. We must, for example, extend the statute of limitations and the range of available criminal sanctions for sexual abuse of children. The theme for this year's Law Day is justice for all for justice. Each of the actions I've outlined is designed to fulfill the promise implicit in that motto. Let me end where I began. There's never been anything like the miracle of the law in this country. Nowhere has it ever worked the way it's worked here. Occasionally, some errant president will shout at the Chief Justice of the Supreme Court, "Good, call out your army to enforce your edict." But that is more notable for its uniqueness than for anything else. The miracle of this place is that it has worked so well. The courts saying what must be done without any power to do it themselves. And then it's occurring automatically from the other branches of government because we understand what a miracle it is and what a beautiful way to live it is. And we've done it well enough so that after only 200 years in a society that is filled with civilizations much older than that, we are the most dominant, the most powerful ever seen in the world. But we must be doing something right when it comes to the law. And yes, the lawyers are unpopular, but that's always true, always will be true. It was true with St. Boniface. It was true with Shakespeare when he said, "Let's kill all the lawyers." Remember, that was an applause line in his day. And it is a great system, but it could be much better, much better. To make it much better, we need more than words. And what we need are action by the legislature, action by the governor. We want to make a court system that's well organized and responsive to its talented new leader. We want the houses in which justice is done to have the same integrity and solidity as the judges and lawyers who serve in them. We want enough judges to lighten the heavy caseload. We want the judiciary to be a realistic career choice for people of all means and background. We want the police to serve the communities they live in and love. And we want judges and juries to reflect the diversity of the people who come before them. Most of all, we want the confidence and the participation of the people our system is designed to serve. And that, by itself, could help improve the system. We imply all of this in our Law Day theme, justice for all for justice. And that theme is far more than a casual conceit. It is a formula for the survival of the system itself. Thank you for your patience.
Thank you, Governor Cuomo. Just 6 weeks ago, I stood in this room before many of you and took the oath of office as Chief Judge. I was then, and I remain today, deeply honored by the trust that has been reposed in me, and committed to bringing the full measure of my abilities to bear on both the work of the Court of Appeals and the broader ongoing struggle to ensure equal justice for the people of the state of New York. Equal justice, our theme today. The past 6 weeks have been both daunting and heartening. Daunting as I actually confront the magnitude of the challenges facing our state's court system. Many of these challenges are inevitable, for our ideals require constant re-examination as of our principles and practices in light of a changing and hopefully constantly more progressive society. But even a cursory examination of the problems we face makes clear that in New York especially, equal justice remains an elusive promise. Our case volumes are absolutely staggering, and our facilities, as the governor remarked, too often dilapidated, disgraceful, degrading both the public and the process. While all institutions have suffered an erosion of public respect, many feel particularly alienated from the courts and from the legal profession, and public confidence in the fairness and in the accessibility of the courts is, of course, the very foundation of the rule of law and the quest for equal justice. As I contemplate our need to reverse these tides and reestablish the public trust, I feel tremendously heartened by the support of the judges and the court personnel, officials throughout state government, so many of whom are here today, members of the bar and others. We surely do welcome your help. I feel encouraged as well by the thought that although justice for all may continue to be an elusive goal and its quest a daunting one, there are significant steps that we can take that may begin to reverse the tides. I'm proud today to recognize what holds promise as one such step as we receive the report of the Committee to Examine Lawyer Conduct in Matrimonial Actions. I would not preempt Judge Malonis and his absolutely remarkable committee, who are here in the courtroom today. And I would not preempt those who must now evaluate the committee's recommendations by commenting on the details of the report. But I do want to touch briefly on several broad themes that seem especially pertinent to our celebration of Law Day. Justice for all is a theme that echoes in the subject of reform of matrimonial actions, regrettably a larger and larger component of state court dockets. According to public reports, our justice system fails many citizens, particularly women, engaged in matrimonial litigation, and thereby contributes substantially to the mistrust of courts and lawyers. The committee's report focuses first on the attorney-client relationship and then on the court process. The report recommends measures to equalize the footing between counsel and client, to foster demystification and open communication from the very outset of the relationship, and it addresses fee practices that have drawn criticism from the public as sharp and overreaching. Where the legal profession and the attorney-client relationship are a central pillar of our justice system, it is obvious that whatever the particular measures ultimately adopted, we must seek to fortify that pillar in matrimonial litigation and all others. The theme Justice for All means also that court process must discourage and deter delay and abuse aimed simply at wearing down the adversary, which adds so heavily to the financial and emotional costs of litigation. Here, too, the committee's recommendations for early court intervention and aggressive, effective case management hold promise as an example for additional reforms beyond matrimonial actions. I have no doubt that the goal of justice for all would generally be advanced both by fortifying the attorney-client relationship and by streamlining the court litigation process, and I welcome the committee's focus on both subjects. But I see the committee's report also as a significant step toward Law Day's correlative theme, All for Justice. The committee, constituted last summer by the Administrative Board of the Unified Court System, was made up of judges and lawyers practicing in the area and familiar with the special problems of matrimonial litigation. As I know from my own earlier participation as a member of the committee reached out to the public through hearings and gathered data from a wide array of sources, among them the experiences of other states, with the view that its suggested reforms would have wide support. The process, in short, sought to be both responsive to public criticism and inclusive of divergent viewpoints, to the end that genuine improvements could be effected promptly. We've been blessed in the judicial branch with extraordinary groups of this nature, uniting the bench and the bar, and where appropriate, other disciplines and other groups in volunteer efforts to advance our justice system. I think, for example, of the Franklin M. Williams Commission on Minorities, chaired by Justice Lewis Douglas, the Pro Bono Monitoring Commission, chaired by Victor Marrero and Justin Vigdor, the Commission on Women in the Courts, chaired by Catherine McDonald, and many others. I'm enormously grateful to all of those committees, commissions, and task forces for their contributions to what could not be a prouder demonstration of the theme, All for Justice. Law Day is an official occasion for us consciously, deliberately, formally, officially, to rededicate ourselves to the American dream of justice under law. The American dream of justice under law begins with the proposition that it is not guns or tanks or military might that bring us closer to our ideals, but constant, careful attention to the goal of providing a fuller measure of justice to more people. It is therefore most heartening at the outset of my tenure as Chief Judge to recognize and applaud a tradition represented by today's committee report, a tradition of responsiveness on the part of the court system to identified public needs, and a tradition of joint cooperative efforts in addressing them. Both the objective of justice for all and this process for approaching it are surely to be celebrated not only on Law Day, but throughout the year. Thank you. And now, to present the Law Day Awards for Distinguished Service, our next speaker will be Matthew Crossan, Chief Administrator of the Courts.
Judge Kaye, Associate Judges of the Court of Appeals, Governor Cuomo, Attorney General Abrams, President Bracken, ladies and gentlemen. The founders of our democracy believed the promise of equal justice to be indispensable to our form of government. It was belief in the promise of equal justice that made America not just a country of separate communities, but a nation. It was belief in the promise of equal justice that bound together different people from different cultures, different races, different religions into one people, the American people. In the Federalist Papers, number 51, James Madison wrote, "Justice is the end, meaning the essential purpose of government. It is the end of civil society. It ever has been and ever will be pursued until it be obtained or until liberty be lost in the pursuit." But justice is more than a theoretical concept. It is a commitment to action by the government And most of all, it is a commitment by men and women dedicating their lives to the principles of justice. Their dedication and their willingness to do more than duty requires gives life to the administration of justice in our state. To honor the spirit of those men and women, the judicial branch has again chosen to present today its Merit Performance Awards for non-judicial employees. There are 3 awards, 1 for community service, 1 for outstanding work performance, and 1 for heroism. On behalf of the recipients and all those others in service whom they represent, I thank Chief Judge Kaye and the Associate Judges of the Court of Appeals for once again allowing these presentations to be part of the Court of Appeals Law Day program. I would ask that Mario Esposito please step forward. It is often said that the longest journey begins with a single step. But when it comes to making the difficult and often painful journey of helping the less fortunate among us, not everyone willingly takes that first step. One person who did take that first step is Mario Esposito, the county clerk of Richmond County, and the journey he set out upon has eased the suffering of thousands of people around the United States. In 1961, Mario Esposito determined to enlarge the American Parkinson Disease Association, which then was comprised of just 2 chapters in New York City, one of which had been founded by his family. Today, due largely to Mr. Esposito's enduring efforts, the American Parkinson Disease Association has 85 chapters and 43 referral centers serving 1.5 million people afflicted with Parkinson's disease throughout the nation. Along the way, Mr. Esposito, who is currently the association's national president, established the first of what are now 400 support groups for sufferers of the disease and helped create the association's annual walkathon, a major national fundraiser. And as if that were not enough, Mr. Esposito also has found the time over the years to be a member of the board of the Seton Foundation for Learning, a member of the Knights of Malta, and an active volunteer for the Staten Island Hospice. For over 30 years of untiring and dedicated service to the afflicted and the less fortunate of our community, we present to Richmond County Clerk Mario Esposito a Merit Performance Award. To step forward, please. For millions of New Yorkers who live outside New York City, the idea of justice is exemplified not by the heat and passion of sensational trials, but by the tempered daily efforts of our state's city courts. City courts quietly handle hundreds of thousands of civil and criminal cases each year, and in every case, the demand for justice is as passionate as it is in the most sensational trial. In Rome, New York, the city court is able to meet that demand for justice because of the remarkable capacity for innovation and adaptiveness of the court's chief clerk, Elena Wheeler. During her 15 years as chief clerk, Ms. Wheeler has overcome a varied array of challenges. She has found creative ways to ensure that the court fully collects the revenue it is owed, to supplement the understocked court library, and to provide volunteer staff assistance to the judges. But Elena Wheeler is not just the court's chief clerk. To compensate for understaffing, she has also taken on the jobs of secretary to the judges, court reporter, librarian, and even law clerk. She is virtually a one-person, non-judicial workforce. For her extraordinary creativity, initiative, and dedication in service to the Rome City Court and to the people of Rome, we present to Chief Clerk Elena Wheeler a Merit Performance Award. step forward. For 10 years, Willie B. Falk has been a court officer in New York City's family court. For 4 of those years, he has been a sergeant. In that time, Sergeant Falk has proven himself to be an exceptional professional, soft-spoken, competent, efficient. But like all professionals in law and home each morning, Sergeant Falk never knows what hazards he may face around the next corner. On February 24th, 1993, Sergeant Falk was walking along Walton Avenue in the Bronx, near the Bronx County Courthouse. Suddenly, from behind, he heard shouts of "Stop! Stop!" He turned and saw a man running in his direction, pursued by police officers. Unbeknownst to Sergeant Falk, that man was being pursued for just having shot and killed one person and critically wounding another in the lobby of the courthouse. The man was armed, he was dangerous, and he was desperate. As the man approached, running, Sergeant Falk tried to grab him, but the man eluded his grasp. He did not stop. In an instant, the man stopped, turned, and aimed a gun directly at Sergeant Falk's head. But before he could fire, Sergeant Falk drew his own weapon and fired, wounding the man in the shoulder, allowing his apprehension by the police and his eventual trial on the charge of murder. For this act of exemplary courage, not to mention quick reflexes, we present to Sergeant Willie B. Falk a Merit Performance Award. Okay, ladies and gentlemen, that concludes the program. Thank you.
Thank you. Thank you, Mr. Crossan. And now, on behalf of my colleagues, Judges Simons, Titone, Hancock, Bellicosa, and Smith, I'd like to express our gratitude to you all for celebrating Law Day with us, and we hope we will now have an opportunity to greet you personally.